Cox.
So my client is under a no injury plea today, Your Honor.
Hold up, he's pleading no contest, which means he's not admitting guilt. But he's also not fighting the charges. Why take that route? Because it opens the door to something called judicial diversion. But don't let the soft language fool you. This case is about to take a dark turn.
I've been handed a document indicating that Ms. Darnell is going to be entering a plea under 4035-313. Is that correct?
State in negotiating this case.
You understand you'll have to testify truthfully?
Yes, sir.
All right. Then I've been handed a document indicating that there are 12 counts in the indictment, and I'm not going to, at this point, go through them, but you're going to be entering a plea of no contest to count 2. Count 1 is dismissed. Count 3 is dismissed. But the remaining counts, in each of those counts, you're going to have a count attempted child abuse and receive a sentence of 1 year. And what is the effective total sentence in this case? 5 years? All right. So those are running, some are running consecutive, some are running concurrent with each other, but it's an effective 5 years of probation. Do you understand that?
Yes, sir.
Raise your right hand. Let's place you under oath.
Yes, sir.
State your full name for the record.
Jordan Hannah Darnell.
Ms. Darnell, you're here today charged with a multi-count.
So here's the deal, 12 charges, but the result 5 years of probation, not prison. Why? First-time offender, no prior record. And the court's rolling the dice on rehabilitation, fair or too soft. For what's coming next, let me know in the comments. And so here's the deal, 12 charges, but the outcome is 5 years of probation instead of prison. Why? He's a first-time offender with no prior record. And the court is taking a chance on rehabilitation. Fair decision. Or too soft given what's coming next. Let me know in the comments.
Stewart County, correct? Right, and you heard me go through what the effective balance of it is, but if you and Mr. Cox had a chance to go over the indictment, discuss the range of punishment you're facing, the state's evidence, and any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they're going to tell me what their evidence would be if this case went to trial. Do you understand that?
Here's a legal bombshell most people miss. By entering this plea, the defendant just waived every single trial right. No jury, no appeal, no witnesses, no chance to challenge anything. With one signature, the entire courtroom chess game is over. Ever wonder how many people sign without fully understanding what they're giving up?
A plea under this 4035-313 is basically what we call judicial diversion. And I'll get to that again in a moment, but that's a special consideration for someone who has no prior record. You understand that?
Yes, sir.
All right. Do you understand that you have the right to plead not guilty and to have a speedy and public trial by jury in this court? You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Cox could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that that's going to result in a number of convictions? Now, I explained to you that this 4035-313 is a process that's only available to people who have no prior record and have some reason why they should be given special consideration. Do you understand that what that means is you're handing me these pleas, and for 5 years you're going to be on probation. If you successfully complete all of the terms of your probation, which does include testifying truthfully against anyone else who might go to trial in this case, then at the end of that 5-year sentence, you can apply to have your record expunged. It won't happen automatically. You'll have to ask the court to do that, but you understand that's an option that you will have.
Yes, sir.
You understand that if you violate that probation and you don't comply.
This is where it gets horrifying. Administering 30 milligrams of melatonin to children under 8 isn't just sleepy time, it's toxic. We're talking night terrors, vomiting, and lasting trauma. And it happened at a daycare, a place parents are supposed to trust.
Permanent convictions, and they will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes,
You
sir.
understand all of that? All right. You understand everything I've explained to you?
Yes, sir.
Do you want to enter this plea according to that agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anyone forcing you to do this against your will? You understand that I can't accept your plea unless I'm satisfied that there is a basis for it and that you are in fact guilty of these charges. Now, how does the state wish to proceed? Since part of this agreement, it's a no contest plea, but part of the agreement is that she'll testify truthfully against the co-defendants if any of them go to trial, correct? So how do you wish to plead? Do you want her to testify on the record and make an allocation right now? Or you? All right. I want you to listen as the state, and if you'll step to the side, let's let General Allen, whose voice is a little raspy today, let's let her, I want you to listen because this is what they're expecting you to be able to testify in conjunction with. You understand that? All right.
Your Honor, the state would put on proof that between May 1st of 2021 and March 25th of 2022, the defendant, Jordan H. Darnell, was under the supervision of Jamie J. Clark, a co-defendant in this case at Mimi's Daycare in Stewart County, Tennessee. And during those dates, under the supervision and at the direction of Jamie Clark, Ms. Darnell periodically gave 30 milligrams of melatonin to children under the ages of 8 in the counts listed in the indictment, Your Honor, at Mimi's Daycare. While those children were at Mimi's Daycare as a result of the melatonin, had night terrors, were vomiting, weren't sleeping at night, and it had deteriorous effects on their physical and mental health, Your Honor. And that's what the state would put on for proof. And also, while working there, Kristen Clark and Ethan Pulley and Jamie Clark, Your Honor, did try and take the camera down that had proof of administering of the melatonin, and we're going to hide it from law enforcement. It was eventually turned in, Your Honor, but that is the basis of what the
Normally, I would say I'm not asking you to agree with those facts, but you understand that's what the state expects you to testify truthfully to at trial, correct?
Yes, sir.
All right. You understand everything that I've explained to you thus far and what your obligation will be.
Yes, sir.
And you understand if you don't testify truthfully at trial, then that will violate the terms of your probation.
Yes, sir.
All right. Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Cox has done a good job of representing you competently?
Yes.
Mr. Cox, do you know of any reason she should not enter this plea? Anything further from the state? Then Jordan Darnell and docket number 2023 CR1, upon your plea of no contest to count 1 is dismissed, count 2, attempted child abuse, you're found guilty, sentenced to 1 year in the Tennessee Department of Corrections, suspended of probation. And that will be a condition of your probation is you will not be able to work for a licensed daycare center while on probation. Count 4, count 3 is dismissed, count 4, you're sentenced to 1 year consecutive to count 2 plus costs. Count 5, you're sentenced to 1 year concurrent with count 4, a $50 fine and cost. Count 6, you're sentenced to 1 year consecutive to count 5. Count 7, you're sentenced to 1 year concurrent with count 6 and a $50 fine. Count 8, you're sentenced to 1 year concurrent with count 7. Count 9, you're sentenced to 1 year consecutive to count 8, $50 fine and cost. Count 10, you're sentenced to 1 year concurrent with count 9. Count 11, you're sentenced to 1 year consecutive to count 10, a $50 fine and cost. Count 12, you're sentenced to 1 year concurrent with count 11. This will all be on supervised probation. She'll need to see the probation department before she leaves today.
Your Honor, I may have looked at it wrong. There's only
Okay, well, there's several times it's mentioned, I just want to make sure.
There's just $50 fines on the odd counts,
All right.
but then there's just one cost.
Court costs of one count, thank you.
That's all I have, Judge.
You may.